Oh, yeah, I forgot it was your meeting, Freddie. Okay, fantastic. Thank
Yeah,
you.
as long as Eri doesn't mind, then that
Yeah.
way she'll see everything.
All right. So we'll start again, Jeff. I'm so sorry to hear about your mother's health condition. And I wish her the best, and I look forward to meeting her. So
Thank you.
you told me she's 86 and she hopes to be released in a few days. Um, if you don't mind my asking, not meaning to pry into her any HIPAA violation issues or whatever, but she's of sound mind and all of that.
Yes, and this has been entirely on her mind. So, lots of our recent discussions have been around this issue, and
Okay.
yeah, she's quite rational about these issues and the important things.
Okay. And then I'm not trying to sell you on more legal services. I don't do estate planning work or anything like that. But does she have, in addition to her, whatever her estate planning documents are, healthcare power of attorneys, that kind of thing?
Yeah, I'm her primary caregiver, and I'm on the trust and the powers of attorney, and you know everything filed with the hospital, as far as I can tell, is in place.
Okay, good, good. Uh,
I and her doctors. I'll put
I
it that way.
understand. I understand. But you hold the power of attorney for her should something go south.
Yes,
Okay. And do you have siblings?
I have one sibling. She's in San Francisco.
Okay. And is she actively involved in decision making too?
She is. We coordinate. I'm primary, as she's an hour away, but often her work has her more like 2 hours away.
Mm.
So, but
Okay.
but in terms of communication, in fact, since I was out of town, she was um, the person plugged in,
Gotcha.
most directly into the latest health problems.
Okay. Okay. Um, well, let's talk about the backyard neighbor problem that I'm sure Ray and Freddie have already talked to you at length about. Are you familiar with all the issues, more or less?
I believe so. There was a quite a good amount of information that Freddie and Ray had forwarded
Okay.
over an email. So I believe so.
Okay. Well, I just parenthetically, I found it quite the coincidence that both of you have backyard pools. Both neighbors have backyard pools with a lot of concrete and retaining walls. So in that respect, you don't have a conflict of interest in terms of, your motivation. I was just in the abstract wondering, gee, will one person be more affected than the other because of the physical improvements? But it looks like you're both on equal footing there, which is, you know, good as from my view of the world. Um, the other thing is, if I were to represent your mother and the Wheelers jointly, then what I would be doing is not only creating a fee agreement for everyone, but also what's called a waiver of conflict of interest. There are various kinds of theoretical conflicts that can occur when there's joint representation of, two or more parties. For instance, let's say, again, I'm not trying to sell you on litigation, but let's just assume that we're down the road and litigation has ensued. And we're all in lockstep at the beginning of the litigation, but then halfway through it, one person or other, it could be, for instance, your mother because of her health concerns or her money concerns or whatever, she might want to just end the lawsuit, whereas the Wheelers want to continue until they get the remedy that they seek. So that's the kind of a conflict where if I'm representing everyone, I've got to act in the best interest of everyone. And if I can get unanimous approval, that's great. If I can't, there might be a time where one or both parties want to get separate counsel. So it's just again, a theoretical problem. I'm not saying it will happen, but that's the kind of conflict of interest that could arise. Same thing with if there was an offer of settlement. One side says that's good. The other neighbor says I want more. That would be another conflict that needs to be sorted out. Right now, it's easy. There's only two parties. It's not like we've got a group of 10 or something where we'd wonder, gee, should majority control or something like that. It's two parties, so the decisions would be 50-50. Um, and in fact, one party could settle and the other not. I mean, you don't have to stay in lockstep just because you began together. So, in many respects, your mother would have all the flexibility as if she were separately represented by an attorney in terms of decision making. The decisions are hers to make. All I would ever tell you is, what your options are, what I would do if I were you, what your neighbor wants to do, but the decision is ultimately going to be your mother's as to her property. And same thing with the Wheelers as to their property. If both parties were to employ my office, then we'd send you a copy of everything we did on your behalf, and anything we received from the other side. In brainstorming this with the Wheelers last week, when I saw their photos, it's a lot of legal terms were thrown out, such as prescriptive easement or adverse possession. And without knowing more about the survey, we need to get our own survey, I think. But without knowing more, I said, well, it's another legal term of art that has gained much more popularity the past decade, and that's called an equitable easement. An equitable easement is kind of like what you have here, where if there was an error in where the improvements were installed, but that error has resulted in the construction of something that's hardscape, that's material that should stay in place to protect the rest of the property or the rest of the improvements, then the court, as a matter of equity, might say, okay, we're going to let those improvements remain in place for as long as they have to remain in place, or their lifespan, if you will. But if the property were damaged because of fire, earthquake, whatever, or somebody came in to bulldoze something and start fresh, then maybe that would be the termination point for that kind of an equitable easement. Probably wouldn't affect your mother, given her age and stage, but it could affect a disclosure issue for a future buyer. So an equitable easement is to maintain improvements. The classic example is there's a garage was built and it encroaches over the boundary line. Well, we're not going to tear down the garage. It was there for many, many years. So we'll let the garage stay there as long as it stays up. But the minute it comes down, well, again, because of fire, we can't encourage the neighbor to create arson or anything, but because of fire or something else, then that would be the termination point. When a new garage is built, it has to be built within those boundary lines. Those are the kinds of issues, and again, we can drill down into it further if needed, but at first blush for me, once I saw the photos, it looked like, oh, this is a classic equitable easement case where even if we're wrong on or the developer, not we didn't install the improvements, but even if the developer is wrong on where the improvements were installed, that doesn't mean we are harmed by it. We get to have the benefit of it. The other thing about, again, kind of like inside baseball, inside litigation, I would normally start out with a letter to the neighbor explaining the issues, the impact on my clients, and why we have to maintain the issues, the improvements, and not allow the fence to be pushed back. Even if we win on that issue, the headache is this new state law that allows ADUs to be built within 5 feet of a boundary line. It is possible that the city could say, well, the boundary line is the boundary line. She can build within 5 feet of that, which is now the fence line. So that literally she could build right up to the fence line of your mother's backyard property. That's a risk. We would want to push it back even 5 feet more, obviously, but we may not have the ability to control that. Just as we want equitable relief, the neighbor, might be able to prevail upon, whether it's the city or a court, to allow her to build right up to the existing fence because it's about 5 feet away from the boundary. And I know that's not what you want. I was telling the Wheelers last week, I was just at a different client's property and I saw an ADU behind them that had gone up in the past year since I'd been there. The ADU had nothing to do with my case. My case was a different issue, but I was surprised how close it was to my client's backyard fence. And it was one of those modern structures. So it was a modern flat top roof, which made it even higher. It didn't have a sloping roof that would have been a more gentler appearance. So it was pretty stark. So that would be kind of a worst case scenario, I think. I don't think that she'd be successful in moving the fence. I don't think she'd be successful in forcing you to relocate your retaining walls, let alone your pool and hardscape around it. But, and here's the big but if the neighbor wanted to push it and push it as far as she could, then we'd have to engage in a lawsuit remedy. Here's some other legal terms of rights you may have heard over the years. And one is an injunction, to get an injunction to stop somebody from building. That's what I call a fast lawsuit. Most lawsuits, people file a complaint, the other side answers, there's some pretrial discovery, things take their pace. Trying to get an injunction is what I call a fast lawsuit, in that there's a lot of work done at the outset. I mean, we not only file a complaint, but we file an application, a petition to the court for what's called an order to show cause and temporary restraining order. So order to show cause is called OSC. Temporary restraining order is a TRO. In order to get that, we'd have to file our application, notice of hearing. We'd have to file a declaration with photos from each of you, as well as a legal brief. And then there's usually 2 court hearings to get that. There's the first hearing to get the TRO, that's temporary, until the next hearing, which is about 3 weeks later. At that hearing, the court decides whether or not there are, because by then, during those 3 weeks, the other side has a chance to file their written opposition for the hearing. And then, once the opposition is received, we can file a rebuttal papers, and then the court hears the matter. If the court agrees with us, which I think they would, then we get it's no longer called a TRO, now it's called a preliminary injunction pending trial. That's the good news. And of course, pending trial could be 12, 18 months later. The bad news is the court would require us to post a bond. The public policy behind posting a bond is, okay, we've stopped them from doing something, but if we were wrong in doing that and getting that injunction, and it's caused them damages, then the court wants a bonding company to stand there for a certain amount of damages. Now, usually it's about a $25,000 bond. Doesn't mean we have to post $25,000, but usually the cost would be about 10% of that, so $2,500. It's like buying a fixed term insurance policy. And it would be a sunk cost. It's not like we'd be able to get it back at the end, that $2,500. Just like the attorney's fees would be a sunk cost. We don't really have a right to ask for attorney's fees here either. So there are some expenses along the way. And the cost of it, filing that fast lawsuit and going through these injunction steps, the parties could easily spend, $15,000 or $20,000 in the first 2 months of the lawsuit. So that's a problem. It's not just because there are 2 court hearings, but we don't know what the court will do. The court might say, well, I'm hearing this, I'm going to continue it one more time so the parties can go to mediation, maybe resolve it on their own. In which case, we don't have an order. It's like a sword of Damocles hanging over both sides. He wants to go to mediation, thinking that we could win or we could lose. And the same thing with the neighbor. They could win or they could lose. And then mediation adds yet a whole nother layer of cost. So with all that in mind, I'd probably write a letter that's nicer than you would think in terms of my opening shot across the bow, in terms of just how we value our relationship with our neighbors. We want to have a positive result. We don't want to cause them any financial hardship as far as their plans, and then go on with what we want. Because my letter would be evidence too in future action. Hey, which brings me to a good question. Has your mother, Jeff, ever corresponded with the neighbor? I know she probably got an email, but did she ever respond or anything like that?
I'm not aware of any correspondence. I've heard stories where I'm not completely accurate, confidence in the accuracy, but they came to the door a couple times or maybe even 3 times.
Okay.
But that's all I heard about, just knocking on the door and talking.
Okay.
There could have been a correspondence. I don't know.
It would be good for me to have you find that out once your mother returns home, just, so we're not blindsided with anything. I'm assuming it's just going to mirror whatever was sent to the Wheelers, but
I think at least what Ellie told me was Sunday, March 10th, she answered her door, and I think they had said they had come before, but she didn't answer the door. But I'm not certain on that, but she did answer the door on March 10th. And
Okay.
they just came with no notice and just knocked on her door. And then after they talked to her, they came and knocked on our door. She said that they told her essentially their story, that they'd had a survey done, that they were planning on doing some work in their backyard. They handed her this document. Oops, sorry.
Okay.
They handed her this document, and I have it, Jeff, since she went off to the hospital. I thought it was different than ours, but it's exactly the same.
Okay.
It's
I've
there.
seen that.
Yeah, it's exactly what you saw. Okay.
Yes,
And it's
but
exactly the same as ours. And they told her that, you know, that her fence was on their property. She said she got very upset with them, and, you know, she was very upset with them. And I forgot what she said to them, but she was like, I can't believe you're saying this. And they told her, well, you know, we just came here for you to think, we just wanted to tell you this, and we just want you to think about it. And then after they left her house, they came and knocked on our door and basically said the same thing.
right.
And they wanted to see our backyard. They also wanted to see her backyard, and she did let them out in her backyard. They took pictures of our backyard, which we let them do. I suspect they took pictures of your mom's, you know,
Right.
backyard as well, Jeff.
Okay.
And I asked her point blank, are you planning on building an ADU? And she said yes, and a gazebo.
Oh,
So that's what we found. And then, you know, we just said, well, okay, you know, we hear you, we understand what you're saying, and they left.
Right. And just, I mean, they did not make any demands or anything like that.
No.
The way they put it was, first, nothing is imminent, they said. We're not about to, you know, we don't have some deadline that we're going to start construction on whatever they're planning to do over there.
But we have hired an architect.
Right. And she said, we just want you to have an opportunity to think about it. You might want to get your own survey. So I don't, you know, it's not clear what exactly they're asking for. But I think Freddie's, and you're right, Harry, is probably this ADU is the main culprit in the whole thing. But they haven't made a demand. They just said, giving us time to mull it over and think about it.
Okay. Yeah, Jeff, one of the things I talked to the Wheelers about is an ADU doesn't have to be pushed back to the fence line. I mean, I've seen ADUs that are even attached to the main house.
Yeah.
But then the Wheelers pointed out the weird configuration of their house where the driveway really goes down slope and from their main house. So I'm not sure, but you know, again, creative architect might come up with a solution that doesn't go all the way to the fence. That's certainly what we would want. Okay. So Jeff and Freddie and Ray, I would say one thing that would be important would be for each of you to put together a chronology. Obviously, Jeff, in your case, you have to talk to your mother. Did you ever live in the home, Jeff, when you were growing up or anything?
that is the home I you know, grew up in from say the ages of 14 to college age.
Okay. Okay. Well, might need a declaration for you yourself then. Who knows? But I would talk to your mother and put together a chronology of what she can say about the house, the improvements, you know, any communications with the neighbor, and then any of her opinions about what the negative impact would be if she were forced to remove the retaining wall and bring it closer to her home 5 feet, and the impact on the backyard and the use and access to the swimming pool and all those kinds of things. I would work on that kind of a chronology, and the same with you, Freddie and Ray. I would put together your thoughts, because as you can tell from what I said 10 minutes ago, there may be a declaration in your future if needed. Hopefully not. But it's good to get your thoughts down while you can.
So
And
when you say a chronology, could you be more specific, Harry? What,
Well, sure, I'll do it in Ellie's case, because she's not here and we're recording this for her. You know, I'd want to know when she moved in, you know, the year and month if possible, year and month possible she moved in. What was the condition of the property at that time? I'm assuming that the retaining wall and swimming pool were already there. Maybe I'm wrong. Maybe the swimming pool was installed later. Was it there when you moved in at age 14, Jeff?
It was, you know, I'd have to think about the timing, but it existed.
Okay.
But then the entire yard was redone in a major landscaping remodel with including an outdoor kitchen.
Nice.
I think it's just outside the area we're discussing right now, but the new pool surrounding and hardscape and outdoor kitchen and gazebo and all those things were put in the more recent past.
Well, so I'd want to know those kind of dates and times. You know, what was there when she bought, what upgrades or changes she made during ownership, and then you know, what would the negative impact? It wouldn't be just the, you know, cost of redoing the retaining wall or the cost of losing some trees or bushes. It would also be the shrinkage of the backyard, so the loss of privacy, loss of any use. You know, those kinds of issues. And this is just between you and me. It's not something we're filing with the court right away. You know, we'd have a chance to review it and tweak it and get it right. So it'd all be attorney-client privilege at this point. So I would just create it as a memo to your attorney, keeping it privileged that way. And then same thing for the Wheelers. You know, that's what I mean by a chronology of not only what happened, you know, year you bought and everything since about the backyard and its improvements, but also the impact to you, and why you would object to having this change. The one thing we don't want to waste too much breath on is views of an ADU. You know, that's a problem. That's, you know, as I was talking with Freddie and Ray, you know, the cram down power of the state has created this headache for many people, not just you. And while we might lament that, just like we could lament the noise and the dust of construction, those aren't going to be issues that get us anywhere, because noise and dust and construction happen with every case. And now with ADUs, they all happen within 5 feet of a boundary line. You know, it's just.
I understand that, and I realize it's an administrative approval. What I wanted to ask about that is, suppose they knock the fence down during construction of the ADU, then what? You know?
Well, we'd want it reinstalled in the same place, you know.
But it would not affect an equitable easement.
No. If we knew when they were going to start construction, we would want to get a commitment from them not to touch the fence. And if they wouldn't, then we'd be at our crossroads. Does that mean we're filing a lawsuit? And not everybody wants to enter my world of litigation. You know, here I'm telling you all about litigation. I'm not trying to sell you on litigation. You know, it's expensive and it's time consuming. There's no guarantee of success. But just like, you know, doctors are sometimes accused of selling surgery, lawyers are sometimes accused of selling litigation. I'm not trying to sell you on litigation. I'm just trying to tell you it may be the only way to stop a serious problem. That's all.
I want to ask you something. Is there a way to either sue them, or I don't know how to do it, but is there a way for us to gain title to that property?
Okay, so that would be ideal.
Yes.
It may require a lot line adjustment. And if there's a lot line adjustment, and it was consensual, meaning that the neighbor agreed, they might be willing to agree to do so for money.
Yes.
You know, if that's the case, then again, we could even use their surveyor to determine the line if there's no controversy over the surveys. But a lot line adjustment would have a filing fee with the city. And assuming it doesn't create a non-conforming use, then it could be agreed upon. I'm going to predict that the neighbor might not want that. They might want the advantage of having as big a backyard as possible. But if it's consensual, that would be the way to do it, is to buy a lot line adjustment. If it's non-consensual, meaning we want the court to issue an order, that goes back to what Freddie and Ray talked to me about last week. Can we get adverse possession? That may be difficult. Adverse possession, it sounds like, gee, the fence has been there forever. Isn't that good enough? But one of the elements of adverse possession is, in effect, like squatter's rights, a knowing intent to take it over, even though you knew it wasn't yours. Here, this seems more like everybody thought the fence was the boundary line. We didn't really have any intent to take somebody else's acreage with, like a squatter might. So that's going to be a hurdle for us. But we can always be assertive, ask for quiet title, ask for the adverse possession, and then in the alternative, ask for the equitable easement. So
Harry, I of course did some looking around Google when this first came up, and
sure.
at adverse possession. And I know one of the factors there is that you've paid taxes on the
right
on your property that included the adversely possessed part.
Right.
And that's probably and I'm not sure how we would be able to show that, since
right.
Possible that I think our property taxes are based on parcel.
Right.
Is that a problem for adverse possession too?
It could be. However, our contention, and again, it's a problem, I agree with you, but our contention would be, well, when we paid our property taxes on our property, we thought it went all the way to the fence line, and therefore, in our mind, we were paying the appropriate property taxes. But that little 5-foot strip, the length of her backyard, is not separately assessed. It'd be one thing if she had two parcels, one for the rest of the property and one for that back 5 feet. Then it'd be a real problem. Then it was separately assessed and we didn't pay it. Here, it's not segregated out by anybody, by you, them, or the assessor. So of all the elements, that may not be as critical as some, but it is yet another hurdle for us.
And on the hostile possession,
Where's that?
aren't there some? I mean, I had thought that if the parties are mistaken,
Mhm.
and you've been, and you just gone your merry way, that was enough. But is that not right?
Not usually enough, but I think we would still start with that, go for adverse possession, and then again, in the alternative, equitable easement.
So
Okay.
let me ask you a question. It seems to me that if you are, you made a statement about, well, if she won't go, if you sue for to quiet your title on the basis of adverse possession,
Right.
and she realizes that, okay, maybe we won't get that, but we will get an equitable easement, which means she's not getting that 5 foot. That wouldn't she then be stuck with, well, it seems like at least if, okay, I could sell that 5 foot, at least I'd get some money for it.
You would think, but again, you might win that battle, but that doesn't necessarily mean you won the war. She, the neighbor, might contend, okay, you got a 5-foot easement, but the state law setback requirements for ADU ignores easements.
I you know what? I know that, and
Okay, fine.
I understand that. I have been on the forefront of advocating against that for since it first was in
Gotcha.
the eyes of the weasel little legislators in Sacramento. Okay, but I totally understand that. Okay, and I don't, and I don't like it, but I do know I can't do anything about it. What I don't want is I do not want to end up with this disclosure situation when we go to sell this house. Either our heirs do it after we die, or one of us has to do it after the other passes away, then we have to go to the nursing home, or I do not want to end up with the disclosure issue. I really want that to go away.
Okay.
And, it's messy. I don't like messy for,
I hear you.
on the title to the property.
I hear you loud and clear. Uh,
And
and
I'm not sure if, I know Ellie's not happy about this, but I don't know if she feels quite the same way.
right.
You know?
I understand it. There may be some entanglement that has to be disclosed later, depending on how this resolves. But yes, I understand. We'll try to make it as simple and clean and easy and positive a result as possible.
I'll talk to her about it. Oh, I'm sorry, Harry.
No, there's one other concept we haven't talked about, and that's called a license agreement. The difference between an easement and a license is a permission to use the space, so it's kind of like an easement in that regard, but it's more personal in nature, won't run with the title. So for instance,
It won't run. It will not. No.
so for instance, if the neighbor were to suggest, oh, you Wheelers and you Zayas family, yes, you can have it for as long as you own your property. Well, again, that means that the new buyer may be confronted with a problem. So I just want to throw it out, not that we want a license agreement, but just so you know that might be something that the other side suggests.
Okay.
We'd rather something that was permanent nature, ran with the title, so you'd have the same backyard you have now to be able to sell to a future buyer. And it may be that we don't care so much right now because you're going to live there the rest of your life. And as I use a phrase about my wife, move out in a pine box. You don't care so much about the disclosures, but your heirs will.
Yeah.
And we want them to be able to sell what you have and have enjoyed, type of thing. Okay.
Yeah.
Other questions or concerns you might have?
I have a question from a somewhat different direction. So I think with our house a mile away here in Los Altos, we're about 20 years ago, we're somewhat on the other end of this, which we did a major remodel and put a second story on.
Okay.
And then in terms of the city and the planning and the permitting, we had one particular neighbor of the 5 or 6 who would be affected that really didn't like what we were doing. And it created quite a problem that we wouldn't want to have. We actually ended up changing a little bit of our design. Is there an analogous situation here whatsoever, even on just the psychology of the situation? Is it like a large remodel? Do they have to get the neighbors to buy into what they're doing? Is it related to why they came over to begin with?
Sadly, these ADUs are ministerial approval, meaning there won't be a hearing. It will be approved or not approved by staff at the staff level, or what we call over-the-counter approval. What we can do, though, is voice our objections to staff so that they, in turn, hopefully, require some modifications. So, for instance, and I don't know what happened with your remodel, Jeff, but you know how sometimes a neighbor might object on invasion of privacy. Your second story will overlook my backyard. Well, the city planners might then say, well, put in what's called a clear story window. Clear story, one of those windows that are higher. They go, like the width of a room, that rather than vertical, they're horizontal. And people theoretically can't look out the window and look down. I don't know enough about this ADU. Obviously, they haven't even gotten their own plans together yet. But it might be that we could get some tweaks to it, such as requiring clear story windows, if any, out that side, so that they don't have people looking into the backyard swimming pool areas. There might be other suggestions based on your experience that you'd also want to incorporate in any requests of the city to accommodate our needs. Okay.
Yeah, I wonder, maybe this just requires information we don't have yet, but it sounds like potentially it's a bargaining chip.
Right.
Okay.
Right.
But I have to say, because I've kept up very carefully with everything going on about the ADUs, and even the permits, the fees that they talked about at last city council meeting, I think they're waiving the permit fees for ADUs. They are encouraging ADU building like you can't believe because they count against the RENA numbers.
Right.
And they will, I just, Jeff, I honestly would not, I wouldn't count on having any leverage at all.
No, yeah,
And
it's
the
not
other
good.
thing is if they make an exception for us, they'll make it, then they're going to be, they'll feel like they need to start making exceptions for everybody. And their policy is to build as many ADUs as possible and to make it as absolutely easy as possible for any person in this city
Right.
to build one.
Yeah. I'm
Hmm.
sure those are accurate comments. So
Okay.
we'll do what we can. All we can do is what we can, you know. Write your congressman, as I say.
No, don't bother. They
Don't
are
bother.
absolutely for this.
Right.
Elect no
Okay.
one, I think.
Yeah, we live in quite the progressive state at this point. Yes.
Another thing that probably another long shot is, and I haven't honestly looked at this neighbor's situation, like with the way the land, the drainage, the geology of the situation, but over further, no commonality, Freddie and Ray, with your property line, but the Lafari straight behind us, they are way up in a hill, and that last 5 feet is nothing but a steep hillside that hopefully holds. So I wonder if I'm assuming this neighbor, there's still elevation in terms of how they sit above our house, which makes me worry about what construction they're doing, which may impact important things like drainage and
Right.
mudslide, things like that. I don't know if that's
a big consideration.
Right.
And I wish we could get in their backyard and have a good look at their backyard. And maybe, you know, we should just ask to go
Right.
back there and take photos because we allowed them to come in our yard and take
Right.
photos. Maybe it would
I
be a
think-
good idea to, you know,
Absolutely.
go over there and just knock on the door and say, look, we're following up and, you know, we would really like to see your backyard and take photos so that we can understand what you're dealing with.
Right. You can either do that directly or let me do that on your behalf, either way. I mean, the request.
What do you think? I mean,
Well,
right now they don't know we're not being friendly.
right.
So
Well,
if we went over there to like tomorrow and said,
Yeah,
would you mind if, you know, we're just trying to work this out, trying to get this in our head, and we'd really appreciate having the opportunity to
Sure.
see your backyard and see what you're dealing with, and
right.
would like to
I think
take.
that'd be great. That'd be great.
Why don't we try? Okay,
Okay.
we'll try and see what they do.
Okay.
And if we can get that, then we'll at least have an idea of
Right.
what their backyard looks like.
Right. All
Because
right.
you're right, Jeff. There, you know, when I look at your mom's, you know, when I look at Ellie's backyard and how high it goes up, you know, in the opposite corner, you know, the exact opposite of the side that joins our yard, it's like, I really can't even in my mind think about what's back on the other side of that.
yeah, there's at least where I've looked and I know well, like the property line with the Lafaris, it's incredibly steep.
Yeah.
So I really like your suggestion with especially when we're in this mode of friendly
Yeah,
investigating it, and I'm happy to go over with you or go over alone as well, you know, to take photos. I'm pretty sure tomorrow I'm going to drive over and look over the fence from our side too, because I haven't ever done that. It's the other neighbors that I've been able to look at easily or just know over the years, but I have no familiarity yet with this side.
Well, you can both go together then. Hopefully, Freddie can set it up. And that's a great idea. And then you can mention in passing if she talks about talking to her architect, you might just mention in passing, you know, some people put their ADUs adjoining their house simply because of the configuration of the property, rather than, you know, in this case, it'd be harder to earthquake proof a foundation if it's on a slope. You spend a lot more money on the infrastructure rather than the cosmetics of an ATU. So you might just be able to drop that in passing.
Okay, okay.
All right. All right. And so Jeff, talk to your mother about what we've talked about. Share the audio with her or the video, and we can talk further. Just so you know, my schedule, I'm here through Thursday, and then I'm out Friday and all of next week. But I'm happy to, if your mother gives me the thumbs up, then I'm happy to send a proposed fee agreement to both of you and get that going and be able to answer any questions your mother might have after hearing the audio. Okay? All right. Well, thank you both. Thank you for being available. And Jeff, my heartfelt wishes that your mother recuperates fast.
Thank you, Harry.
All right.
Thank you.
Thanks, Harry.
Okay.
Thank you. Thank you all.
Thank
All
you.
right. Good
Jeff,
talking.
Jeff, do you want to stay on for just a minute and we can try to coordinate tomorrow? Thank you, Harry.
Perfect. Thank you both. Bye.
Okay, so Jeff, I have to go to physical therapy at 10:45, but then I'll be back. I don't know about these two people. I suspect they are both working during the day.
You know, I drove by that house last week. Last week, and you know, the little red car they came up
Yeah.
here with, that was out in front of their house on a, you know, every time I've gone by there, because I was trying to get an idea of what it looks like.
Oh,
So he may be, since he works for a New Jersey
he may be remote.
company, and I think he might well work at home. Would not be surprised.
Oh, I bet you're right. I bet you're
And
right.
I don't know whether she's still, as she described herself, how many years ago to you?
23 years ago.
Working for Cisco Systems. I'm a or I don't know what she said she was, but anyway, I think there's a good chance somebody would be there, but it doesn't hurt to try. Plus, Freddie might like to, you might get a pretty good view of the thing by looking over your fence from your backyard.
Yeah.
We really can't see it very much from our house.
Oh, interesting. Yeah, I mean, I'll definitely do that. I have time various times tomorrow. Is it sounding like we have a chance of catching them in the late afternoon?
Maybe
Then
so.
pretty good.
I think, why don't you want to try sometime tomorrow afternoon, and just whenever you come by, just come on over and maybe we can go over there together.
Yeah,
We can
yeah, we
look
don't
in
have to
your,
worry about.
we can look in your backyard first
I'll
and
do
see.
that first.
Yeah, let's look there first to see.
Yeah, so I can protect my time after 3. So maybe what I'll do is I'll block out my calendar, drive over there a little after 3,
Okay,
stoop around from my mom's backyard, and then come over to your place at 3:30. Does that sound
Okay.
okay? Target
that's
that.
perfect. Yeah. Okay.
Yeah, I
well,
know my mother, I assume we're still recording, but I know she did not have a pleasant conversation with him whatsoever.
No,
But I think it's, we could go over there, and I think it's actually great now that you mentioned they were able to photograph. I didn't know they photographed in my mom's yard, and I didn't know they photographed in your yard. So to reciprocate, it seems like the odds are pretty good.
yes,
And
I
that
would think so. Okay, good. Well, so we'll just expect around 3:30-ish tomorrow.
Yeah,
Okay.
that's great. Thanks for all the communication and setting all this up. It looks like the very best thing to be doing, given the unfortunate circumstances, but got
Yeah.
to do the best we can.
We do. And then as soon as I hear from the, Mirko, from the
Survey.
Leah and Brad, however you pronounce that, Leah and Bray's surveyors, as soon as I hear from them, but they may also, did they copy you on their response to me? I didn't.
I saw the request and a response where they were gonna put some records and then give a quote.
Yes. So
Yeah.
we'll know. I'm hopeful they will also copy you whenever they respond, so that we'll both know exactly what they're doing and when they can do it.
Perfect. Yeah, and I feel like my questions don't come from a place of knowledge in any of this, but I wonder if the surveyor, also knowing that the grading and drainage and stuff like that can be an issue, I wonder if that's something they could pay special attention to also, because it may
Oh.
be
That's a great idea. Yeah, maybe so. Yeah. We can certainly, ask them, if that's something that they could opine on, or maybe they could just tell us something, talk to us
Right,
about
ask
how
them.
bad that would be.
Because then you couldn't hire somebody if you had to.
Yeah, I just have these vague memories of like mud coming down and just going all the way across the underside of my mom's house, right? I mean, these are real, regardless of these property legal type issues, I think these are real issues given, if we have more atmospheric rivers and,
Yeah,
the
yes,
more they're changing over there above us, the worse it could be.
absolutely. Yeah, yeah, I didn't even think about that, but that grade is unbelievably steep. I was trying to take a picture of it, when I went over to talk to your mom, and unfortunately the sun was right up at the, at the edge of it. So it didn't really wasn't a great photo. I just send to Harry, but we can get better ones, and we can also see what their side looks like. So you
Okay.
have that walkway. There's stairs that go all the way up to the top, I noticed.
Oh, yeah.
And
Yeah.
I wonder if you can stand on the top of that and look down into their yard.
I think all we can see from there are the Blafaris and the neighbor to the other side of the Blafaris. But I'll give that another shot. But I think that's more on the Blafaris side
Okay.
of the property. So I can't. Yeah, things are so steep there. I think we're blocked at that point, which is why I don't know this other neighbor's yard whatsoever. But
Oh,
I'll take another look, definitely. And this
okay.
will be part of my homework too, because that hill. When I was a teenager, my father and I, he had this idea of getting a bunch of used railroad ties dumped off. And I think he ruined his back to an extent, but we split the railroad ties and terraced that whole hill.
Oh,
And then
wow.
15 years after that, my mother, I think, realized, or they had enough money, well, let's have it professionally done. So it's more of a beautiful set of terraces, which it is now with
Yeah.
a walkway. But that hill is it was unterraced when we moved in, and it's very important. Like it's very well terraced and with concrete walkways on each level. Otherwise, that whole hill would have slid down by now. So anyway, a little bit of the history.
But that's good, and those are good facts for us, and for your property, those are good facts. The more improvements on that property, the better, the close to the, to the disputed fence line. So,
Yeah, absolutely.
okay, Jeff, well, we'll see you tomorrow. And if you see Ellie in between, say hi for us, okay?
Yes, I'll give you an update. I'm checking with her every 4 or 5 hours, and yeah,
Okay.
but she seems to be slowly getting stronger.
Good. All right. Well, you take care. All right.
Okay.
I'll send you
Bye.
this. I'll make this a YouTube, and I'll send you the link by email.
Okay, fantastic.
All right.
Appreciate it.
Take care.
See you.
Okay. Bye-bye.